Most landlords don't lose money on bad tenants. They lose it on bad leases. And that one sentence could save you thousands of dollars you didn't even know you were hemorrhaging. We're talking about a single document standing between your investment and a courtroom, and most people treat it like a formality. The lease is not a handshake with legal formatting. It is your first and last line of defense when everything goes sideways. And trust us, something always goes sideways. Think of it like the foundation of a house. Nobody sees it, nobody brags about it at dinner, but the moment it cracks, everything above it crumbles. Here's what's wild. Vacancy rates in some of the hottest rental markets are sitting below 5%, meaning landlords got so comfortable collecting checks that they forgot to protect the machine printing them. Confidence in a hot market is the exact moment you stop reading the fine print, and that's precisely when the fine print bites back. The catalyst for most legal disasters isn't a scheming tenant with a law degree, it's an ambiguous clause that means one thing to you and something completely different to a judge. We've seen landlords lose eviction cases not because they were wrong, but because their lease said reasonable notice without defining what reasonable actually means. Behaviorally, landlords fall into a trap called optimism bias, where they assume their tenant screening was good enough to make airtight lease language unnecessary. That's like buying car insurance and then driving with your eyes closed because you figured you'd never actually need it. The biggest misconception floating around landlord Facebook groups, yes, those exist, is that a lease downloaded from the internet is basically the same as one drafted for your specific state and property type. California, Texas, and Florida have wildly different landlord-tenant statutes, and a generic template is essentially a legal time bomb disguised as productivity. Here's the historical irony. The strongest tenant protection laws in American history were largely built in response to landlords who abused vague or non-existent lease language decades ago. We essentially wrote the rulebook that now governs us because enough people played fast and loose with agreements, and the courts stepped in to clean it up. So what actually reduces your legal risk fast? And we mean practically, not theoretically. Start with hyper-specific language around 3 areas: rent payment terms, including grace periods and late fees, property condition at move-in documented in writing, and the exact process for maintenance requests and landlord entry. Entry clauses alone are one of the most litigated issues in residential rentals. And most leases just say, landlord may enter with notice without specifying how many hours, in what format, or under what exceptions. In many states, failing to give proper notice before entry isn't just rude, it's grounds for the tenant to break the lease penalty-free and potentially sue you. The community of experienced investors will tell you something that sounds boring, but hits like a freight train. The lease negotiation is actually your most important asset management moment. Every concession you make verbally that isn't reflected in writing is a liability you voluntarily handed someone else. Seasoned real estate attorneys, not paralegals, not property management software, will often charge between $500 and $1,500 to draft a jurisdiction-specific lease, and that fee has saved clients tens of thousands in avoided litigation. Think of it as the cheapest insurance policy in your entire portfolio. The disciplined, unemotional move here is to treat lease review like you treat rent collection. Consistent, scheduled, and non-negotiable. Review your lease template every 12 months against any changes in your state's landlord-tenant law, because what was compliant in 2022 may not be compliant today. There's also something deeply philosophical happening here. The best landlords aren't the ones with the highest rents or the nicest units. They're the ones with the clearest agreements and the calmest evictions. Clarity is kindness, not just legally, but relationally. Because tenants who understand expectations from day one are statistically less likely to violate them. Whether the market softens, rates rise, or your vacancy sits longer than expected, a structurally sound lease keeps your downside managed and your options open, and that's the whole game. You can be comfortable with uncertainty when your paperwork isn't the weak link in the chain. If any of this has you thinking about leveling up your real estate strategy, whether that's investing smarter, renovating right, or finding the right financing, check out our links in the description below and let us help you get started.